Welcome everyone to the latest guest speaker event of the U.S. Asian Law Institute at NYU School of Law. I'm Catherine Wilhelm, the Executive Director of the Institute. And today we are returning to the topic of the legal status of Taiwan. Beginning in the fall of 2024, we launched a speaker series about Taiwan using a legal lens instead of the more commonly used geopolitical and strategic lens. Previous speakers have already discussed Taiwan's status under US law, that is the Taiwan Relations Act, under international law, the law of the UN, the law of the Republic of China, which is the name used by the government in Taiwan, and the law of the People's Republic of China, which is the government in Beijing. So all of those talks, we have recordings on our website, and we also have extended written excerpts from those talks. So welcome you to come to our website and have a look. So today, Julian is going to unpack what international law says about defending Taiwan. Contemporary international law has a strong bias against the use of force to gain or even sometimes to regain territory. But because Taiwan's status under international law is contested, that makes the scenario in Taiwan much more complicated than if it was unambiguously recognized as a state. So as most of you probably know, and as we have already discussed, but we'll discuss some more today, the government of Taiwan claims that Taiwan is a state and should have equal standing with the PRC. But the PRC, of course, argues, and many of the states in the world agree, that Taiwan is part of China. So the question of Taiwan's defense is a topic that Julian has written about. He is the Maurice A. Dean Distinguished Professor of Constitutional Law at Hofstra University School of Law, where he teaches, among other things, US constitutional law and foreign relations law, or foreign affairs law. He researches the relationship between constitutional law and international law, and China's relationship to international law. He's also one of the co-founders of Opinio Juris, which is an international law blog that is fairly popular, so that's a very cool thing to have on your resume. He'll start by introducing his analysis, and then we'll have a discussion that I hope you will all join in.
Yeah, well, thank you. And thank you so much, Catherine, for inviting me to participate. It's always fun to come down to NYU, and also an honor to be part of something that the US ALI is doing. Just a quick note, my first encounter with US ALI was, when I met Jerry Cohen, and of course I can't go without just saying, mark my respects for what he accomplished, and this is one of his legacies as well, and it's so wonderful to see that this institute is active and continuing is one of his great sort of achievements, his many great achievements. So it's a great honor to be here. Also great to participate in the speaker series, because I think I really enjoyed trying to sort of deal with what a lot of people talk about, but no one fully understands, which is all those weird legal issues surrounding the status of Taiwan. It's very difficult to sort of talk about. It reminds me of some other naughty international legal issues that everyone has a view on, but no one understands either, like Israel and Gaza, for instance. And so I think trying to advance understanding and knowledge on this topic and the use of force and all those things is really valuable, even if it sometimes feels like a hopeless task to reach any sort of agreement on these things. So my topic for today is to focus in on, we've already discussed, as Catherine mentioned, that Taiwan's international legal status is uncertain and contested, at least in the point of view of many people. And so that raises the question of then what does international law have to say about the use of force either by Taiwan itself to defend itself or by other countries like the United States to help Taiwan defend itself in a conflict with China. So that's my focus today, and that's sort of, not a general conflict, but if there is a conflict with China, what would be the international law rules for governing China, governing Taiwan, and governing the United States in that scenario? Okay. So just to summarize, and it's a little hard for me to see here, but all right, so there are sort of three basic points I want to sort of establish here. One is that this is a topic that China, the government of China and the government of Taiwan are very aware of, and so they've taken measures to to make advocacy on international law topics is very important. It's not just an abstract political claim. It actually has a legal significance. So China's One China principle is something that the Chinese government is very committed to, obviously, but it also supports the legality of a Chinese military action against Taiwan. And it casts doubt on the legality of any US military action to help defend Taiwan. So that's the conundrum I want to tackle today. I want to sort of then explore three international law approaches that might limit or prohibit the use of force by China against Taiwan, and might also allow or authorize the US force to defend Taiwan. But I'll just sort of conclude by noting out that while China's position is quite clear and straightforward, the United States and Taiwan are all over the map. And this actually muddles whatever position they might have on whether international law would permit the use of force to help defend Taiwan. Okay, so all right, so just to sort of jump into just make the background point, which I don't think I need to make to this group here, but the People's Republic of China has never renounced the use of force as an option for it to use against Taiwan in certain cases. And this is enshrined in many documents, but including Article 8 of the Anti-Secession Law, which was enacted in 2005 by the People's Republic of China. And, obviously this is a law which is intended to deter secession. It has many different components, but Article 8 explicitly points out that in situations where a secession has occurred in the view of China, or the possibilities for peaceful unification have been exhausted, the law states that the state shall employ non-peaceful means and other necessary measures to protect China's sovereignty and territorial integrity. So this enshrines, I think, the official position of the Chinese government on what would it do, that it does have the right and, in fact, the legal obligation under Chinese law to use force in certain situations where Taiwan is seceding or Taiwan is viewed to be doing something that would exhaust the possibility of reunification. Okay, so how does this affect international law? So what does international law have to say about this? So international law, there are many different components of international law, but with respect to the use of force by states, this is one of the prime goals of the United Nations Charter, was to stop, prohibit, or somehow restrict the use of force by states against other states. And you see this embodied in Article 2 of the United Nations Charter. All members shall refrain from, in their international relations, using force, the use of force, or the threat of the use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations Charter. So Article 2.4, well known to anyone who studied international law, is a general prohibition on the use or threat of force against another state, territorial integrity or political independence. It's also there's language that also suggests a broader goal of requiring members of the United Nations to refrain from the use of force in their international relations more generally. But the main focus, of course, is on the use of force against another state, the territorial integrity or political independence of another state. It also, in Article 51, though, makes a reference to the inherent right of an individual or collective self-defense if an armed attack occurs against a member of the United Nations. So the Charter also makes clear that nations, even with Article 2.4, nations do not lose their right, what the Charter calls the inherent right of individual or collective self-defense. Importantly, though, this is only if an armed attack occurs against a member of the United Nations. It's important to highlight that language as well. So how does this affect the way China and Taiwan interact, and whether China's use of force against Taiwan will be legal? So China's view of the UN Charter and how this would affect its relations to Taiwan are pretty straightforward. So China's position is, as many of you know, so maybe I can get this up. I know. Oh, here we go. Oh, so you just can't see it on the screen here. Yeah. So I chose poor colors. Sorry. So China's position is Taiwan is not a state. So therefore, China can lawfully use force in Taiwan because if you read Article 2.4 just as textually, it prohibits the use of force against the territorial integrity of any state. If Taiwan's not a state, then use of force against Taiwan is not a violation of the UN Charter. The second part is also pretty straightforward. Taiwan is part of China. This is China's view. And so therefore, the US cannot lawfully use force to defend Taiwan because if the US did use force to defend Taiwan, it would violate the territorial integrity or political independence of China and violate Article 2.4. So this is a very straightforward interpretation. And it's a partial explanation for why it's important for China to not just promote the one China principle, is what it calls, but also to make sure other countries sign on to this principle. And so a recent study has sort of studied whenever the Chinese government establishes relations, or sometimes when they have meetings with countries, the other country will endorse what China calls the one China principle. And there's often a joint declaration, or sometimes there's what they call a communique, where the countries agree to establish relations, and the other country, could be any country, that like Brazil or Argentina, Africa, whatever the country it is, will then say, and we agree to the one China principle, and they'll state what that principle is. Now, China's one China principle is a little different than what the other countries might call the one China principle, but China's one China principle has been something that, according to a recent study, has been explicitly endorsed by roughly 142 countries around the world, around 74% of the members of the United Nations Charter, United Nations. And that the key thing here is that China's one China principle is, just paraphrasing, there is only one China, but importantly, Taiwan is part of China. That's China's one China principle. And of course, I know you guys have, in the series, have explored that question to depth, so I'm not gonna go into it too much more, but the legal significance of that is that it establishes the framework for understanding China's legal position with respect to Taiwan. If China uses force in Taiwan, and Taiwan is part of China, it's using force within China, right? It's part of China. And so therefore, and other countries have agreed it's part of China. So therefore, it's not an international conflict. It's not something that would implicate the United Nations Charter. It would not violate or potentially violate Article 2.4. And if Taiwan is part of China, other countries can't get involved and use force to help Taiwan defend itself against China. So that's sort of why the one China principle, there are many reasons why it's important to the Chinese government, but this is an additional consequence of the fact that to some degree, 142 countries have already pre-agreed to the idea that Taiwan is part of China, and therefore, although they don't say it explicitly, potentially they've also at least agreed to the general idea that the use of force in Taiwan by China would not violate the United Nations Charter. Okay, so that's, I think, a very straightforward, clear international legal position. Now I'm gonna get less clear, and I'm gonna go through three alternative views of Taiwan, which interrelate with Taiwan's different possible international legal statuses, which would argue for limiting or restricting the use of force by China against Taiwan. Okay, so the three theories, or the three interpretations, and here I call it the UN Charter, but really it's of international law more generally, which would affect how we would think about the way the UN Charter interacts with Taiwan. So the first interpretation would be if Taiwan is a separate state, then that would obviously have a different implication for what the UN Charter would say about Taiwan. As we'll discuss, as you've already discussed, this is a hotly contested, difficult to establish proposition. And also, importantly, just from the perspective of the United States does not take the position that Taiwan is a separate state. It also doesn't take the position that Taiwan is not a separate state. It just doesn't take a position. It's America, right? But this is not just America. There are many, about 40 or so countries have effectively taken this sort of agnostic position on whether Taiwan is a separate state. So there's one other approach that's been developed in various scholarly articles, is the idea that Taiwan is a de facto regime, and de facto regimes are recognized under international law to have both rights, but also certain but duties under international law, and those rights and duties would prohibit or at least restrict the use of force against a de facto regime. I'll talk about that one. The third, and this is the most sort of complicated version of this, is Taiwan is part of China, but China cannot use force against the Taiwanese people who are trying to exercise the right of self-determination. So this is a more complex argument I want to explore, which also reflects some views of how some people think about what's really going on in Taiwan. This is really about self-determination. Okay, so let me start with the first approach. So the idea that Taiwan is a separate state, this argument is actually pretty straightforward. If Taiwan is a separate state, then the use of force would violate Article 2.4 of the UN Charter. But interestingly, even if Taiwan is a state, it's not clear it has the right of self-defense, because the UN Charter mentions only the inherent right of a member of the United Nations, which preserves their right of self-defense. It also is not clear that the right of collective self-defense would extend to Taiwan, because it only, again, mentions a member of the United Nations Charter. So it's theoretically possible that, suppose a country says, well, I agree Taiwan is a separate state, you might still argue, and I'm sure you would hear the argument that, but Taiwan may not have the right of self-defense, but certainly the United States does not have the right to exercise the right of collective self-defense on behalf of a state that is not a member of the United Nations system. Now, I'll just mention that this argument, we've had this argument already. All of you are too young to have remembered this one, because there was something called the Republic of Vietnam, or South Vietnam, and it was not a member of the United Nations. The United States nonetheless took the position that it had the right to exercise collective self-defense to help defend the Republic of Vietnam against outside invasion. And there's a long, complicated legal debate in the 1960s within the United States government and the public about the legality of the United States intervention to defend South Vietnam, the Republic of Vietnam. And one of the issues that they dealt with was whether a member of the, because Vietnam was not a member of the United Nations, whether they had the right of collective self-defense, or whether the collective self-defense applied to Vietnam. And the US government took the position, and I think other scholars at the time as well, not all of them, they're divided, that because it's an inherent right of self-defense, should not be interpreted to be limited to members of the United Nations. That a state, if it exists under international law, does not lose its right of self-defense just because the United Nations Charter exists. And so that interpretation, I think, is hard to imagine the United States government backing off that position. And I think other countries would find it plausible that whatever the right is, if it's a state, it still has self-defense and collective self-defense protections, even if it's not part of the United Nations Charter. However, as many of you know, as I mentioned earlier, very few countries actually recognize Taiwan as a separate state explicitly. And so therefore, this argument, while the cleanest for the purpose of international law with respect to making it clear that Chinese invasion of Taiwan would violate the UN Charter, is hard. It rests a lot on the more complicated question of whether Taiwan is accepted as a separate state, which, as you know, is hotly contested. Okay. So the second approach, which has been discussed in some of the academic literature, is this idea that Taiwan is a de facto regime. And I think this does describe, at least in fact, what Taiwan kind of is in many ways. It's a regime which governs a territory for a very long period of time, right? And has sort of established sort of longstanding customs, rules, laws, population, but it's not recognized by other states as a separate state. And this is actually not a unique situation in Taiwan. There are other examples, and other countries will say, okay, we don't recognize you as a state, but we will treat you as a de facto, so not de jure, but a de facto government regime for this particular territory. And sometimes it's during like a wartime situation. So perhaps not the best example, but the Confederate States of America were, the southern states were a de facto regime. Britain, that's how they treated it. The British government dealt with them as a de facto regime, and did, receive their ambassadors and negotiate, but not as official members of a separate state. North Vietnam, East Germany, North Korea, until relatively recently, the United States treated them as non-recognized but de facto regimes. So it's not uncommon for a state to have governance over territory, but for many states not to recognize them as the official government. And some scholars have argued that state practice shows that these de facto regimes are treated as partial subjects of international law and therefore have both rights and duties under international law. And there is a certain amount of state practice that supports this idea. And so, as Professor Furlong argues, who's a leading scholar on de facto regimes, has argued, state practice has, well, he says clearly proves, but at least strongly suggests, in my view, that the prohibition of the use of force applies to de facto regimes as well as recognized states. That if you read the UN Charter and its broader goals to restrict, eliminate the use of force by states, then it would make sense to read it in a way that would prohibit force even against de facto regimes. And again, going back to the Vietnam example, we did have this conversation then. The non-recognition of North Vietnam many states still said the United States was violating Article 2.4 when it bombed North Vietnam, even though the United States said, well, North Vietnam's not a state, we don't recognize it as a state. And so, but there's quite a bit of state practice to argue that nonetheless, even if it's not a state in the eyes of the United States, the US is violating Article 2 of the UN Charter. So, and there's some other examples, but that's just and there's a certain amount of intuition to this argument. There's some international documents that support this idea. Every state has this is the Declaration on Principles of International Law Concerning Friendly Relations. It was adopted by United Nations General Assembly in 1970, which did sort of adopt this is not a binding legal document, but it's sort of, some people have argued has important legal force because so many states embraced it. And one of the ideas in this document was that every state has a duty to refrain from the threat or use of force as a means of solving international disputes, including territorial disputes. And again, the intuition behind this, it makes sense not to, UN Charter is trying to prevent the use of force. Why would you then say it's okay to use force to resolve a territorial dispute? And another idea, another document, 1974, General Assembly resolution, aggression was defined as, is used whether or not, was defined aggression as the use of force against another state. But actually, they added a explanatory note to make it clear that it doesn't have to be a state that's a member of the United Nations or a recognized state. So both of those have been argued to therefore suggest that de facto regimes like Taiwan and other major jurisdictions might have some right nonetheless to be protected against the use of force under Article 2. There's a certain amount of state practice that supported this idea. Not all of it's great, but the United States actually did invoke some version of this idea when it was involved in the Syrian conflict during the ISIS wars in the 2014, 2015 period. The United States invoked the right of collective self-defense to use force to defend its Syrian allies, even though it didn't recognize them as a state, right? So there were Syrian rebels, not the current government, but one of the various groups that were there. The United States actually regularly used force in defense of those groups, and arguing that it was invoking a collective right of self-defense, even though there was no state it was defending. Perhaps a less happy example. Turkey invoked some version of this collective self-defense to defend the Turkish Republic of Northern Cyprus, which some of you might know. Northern Cyprus has been another sort of state, an unrecognized state for the last 50 years, pretty much recognized only by Turkey, as far as I know, but has existed and is the classic example of a de facto regime. And Turkey has suggested it would continue to invoke that to defend if there's some sort of military attack on Northern Cyprus. Okay. So now one final theory. This is the most sort of speculative and perhaps complicated version of this, but I think it does fit the intuition of many people I've known in Taiwan, especially people who are, as the parlance goes, deep, really deep green, beyond green. What's beyond green? I don't know. Whatever really green is. So green that it's blinding. So here, the idea here is that maybe Taiwan, what's really at stake here is Taiwanese people's right of self-determination. And so whether or not Taiwan is part of China, Taiwanese people have evolved to the point that under international law, the people have the right to determine their future under the international law of the right of self-determination. Now, this is a contested idea, but the right of self-determination is something that exists under international law. It's historically been thought to be mostly invoked by colonies in the imperial sort of context and the decolonization context. But as there has been scholarly arguments that it could extend, and Supreme Court of Canada acknowledges in their on Quebec decision, that it could extend to a definable group that's lost meaningful access to the right to pursue its political, economic, social, and cultural development. So this actually argument was most popular in Taiwan actually during the Chiang Kai-shek era when Taiwanese independence activists did make this argument that there was a foreign regime that was China, the Republic of China, that was suppressing the Taiwanese people's right of self-determination. But some version of this, as you know, has been invoked more recently. I think we saw a version of this presented, that Taiwan in 1991 exercised the Taiwanese ROC people, this sort of new group of people, exercised their right of self-determination in their 1991 constitutional reforms. So this idea is this idea that the people have exercised some right of self-determination. And if they have, or if they are a people that has such a right, then there is some evidence that international law prohibits the use of force to suppress a right of self-determination. In other words, if you are a people who does have a right to self-determination, the international law says another state should not be able to use force to suppress it. And there's some examples of this in the literature. I'm not going to go through everything. There's a UN General Assembly resolution that's there's a lot of broad language saying right of self-determination is important, fundamental, should not be suppressed through the use of force. There isn't a lot of state practice here, but Portugal's use of force against its former colonies was condemned in 1972. Other states have sometimes intervened in support of the right of self-determination. Again, it's a little murky exactly, but one example of this, again, not a great example depending on where you're sitting, but Bangladesh was once part of Pakistan. India intervened to support East Pakistan, Bangladesh. And it did, although not the only justification, invoke the right of self-determination of the people of East Pakistan. So this would also then further be a theory as to why a foreign state could intervene to support a people's right of self-determination. The most recent example, again, a little murky in terms of what exactly happened here, but the people of Kosovo were arguably exercising a right of self-determination, which was later accepted by many states that recognized them as a separate state. The NATO countries intervened in 1999 on both humanitarian grounds, but arguably, maybe, also to protect the right of Kosovo's self-determination. But this was not explicitly made by those states at the time. So the state practice here of a foreign state supporting the right of self-determination is much less well supported, I think, as a matter of state practice. So let me try to conclude here, and I'm going a little long here. So which alternative is Taiwan or the US, if there was a conflict, do we think would fit or work? Well, I think the reality is that if there's a conflict over Taiwan, all of these things are in play. and we're probably going to get a mix of all these different theories. For political reasons, the current government in China and Taiwan cannot say it's not a state, nor will it ever say it's a de facto state. It's just not going to work, right? And so Taiwan, I think the government is kind of incentivized to make the argument, we're a state, you can't use force because we're a state. The US position, though, is already kind of murky with respect to what Taiwan is. And this actually fits well that the US could make the argument that, well, we're not saying Taiwan's a separate state. We're not going down that road. But that doesn't mean we don't have the right, and it doesn't have the right to avoid the use of force by China. I think this fits with the intuitions of the current US government policy. And that's, I think, all under the umbrella of the de facto regime theory of why you can't use force of international law. I do think that self-determination one has the most moral force. In other words, when people think about Taiwan, the reason why people get fired up about this would be terrible, among other things, is that people say, well, Taiwanese people are real people, and why can't they choose their future? So, but I do think legally it has some challenges. It's disfavored by many other states that don't want their own self-determination. Spain, for example, is a great example of a state that's very much against self-determination, mostly because of their own domestic issues. So, and let me this last thing, I'm sorry, did I go? Okay, let me just.
No, I'm from Spain.
Oh, okay. Oh, I'm sorry. Right. I know nothing about Spain except that Catalonia is a problem. Okay. All right. So let me just say one last, and here I get to my controversial, even most controversial point. And the background of this is that United Nations Charter does make clear that Ukraine, I mean, there's almost no dispute. Ukraine is a state. It's a member of the United Nations. No one disagrees, except maybe Russia, but not even Russia disagrees on most days. And that did not prevent Russia from invading Ukraine. Now, maybe it made it harder. It'll be better to be protected against use of force than not. But at the end of the day, it's not a great sign that it didn't seem to, Ukraine's still being invaded, and that's not great. And in fact, it's terrible. And there are a lot of contested issues. And so I think my reading of the situation is that if there was a conflict, given the way that most countries have endorsed the view that Taiwan is part of China, there's a small number of countries that haven't. I think it'll be very hard, even I think there's some merit to the de facto regime argument, the self-determination argument, it's very hard for the United States and Taiwan to broaden this argument and make it appealing to the vast majority of countries in the world. And I think I foresee the US losing a General Assembly resolution where it's being condemned for, if it did intervene for Taiwan, it could easily lose a General Assembly resolution and be condemned for trying to defend Taiwan. And so I think what we're facing here is the possibility of the America alone scenario, which is not great either, especially for international lawyers. But it's something that I think people need to think seriously about, and I think have thought seriously about, that even if there's a good or reasonable international law argument as to why China should not be able to use force against Taiwan, that argument is not what lawyers would call a slam dunk. It's far from it. And so I think in a real world situation, I can see massive conflict and the US and Taiwan facing a scenario where they are kind of on the wrong end of international law. And the question is, can you still act? Should you still act in that situation? Well, I'll just say that most of you know, the United States has not been deeply constrained by Article 2.4 in its own, in other areas. So it's hard to imagine it would be deeply constrained here. But other countries that would be very important in any conflict over Taiwan, I'm thinking mostly of Japan, but Australia, South Korea, Philippines, are much more deeply constrained by these principles. And so having a credible, clear, straightforward argument as to what international law says about a conflict over Taiwan is, I think, crucial. So I think the US does need to start legal wargaming a little bit. I do worry that there is a conflict that really will happen now, especially after what we've seen in Ukraine. So I think the US needs to be prepared to be on the losing end of UN General Assembly resolutions, but also be prepared to make credible, serious international legal arguments that could at least rally its allies to support Taiwan in the event of conflict. So I'll stop there. Thanks.
Love it when speakers end with a big provocative question. So I wanted to But setting that aside for just a moment, ask a slightly different question. You're making an argument about the legality of what the United States and Taiwan might do, or what Taiwan itself might do, and then the United States and other allies might do. What about first asking about the legality of the attack on Taiwan and the legality of this presumptive Chinese action? If China's attack on Taiwan is illegal in international law, does that create a whole nother set of counter arguments in addition to the three that you have? Because the three you have seem to be at least neutral on the question of whether the attack in the first place is legal or not. Does illegality of the original attack create room for new arguments about legality of defense?
So I guess maybe if I understand correctly, I think the legality of the attack, I think, turns on whether these three theories, and we accept any of these three theories. So my view is that, China's going to say it's legal, but but I guess the only way to attack the legality of China's act is to adopt one of these other theories. Is the way I think about it.
You don't see any room for an argument because you referred, for example, to Kosovo.
Yes.
You don't see any room for an argument that, sure, Taiwan is legally part of China, but it's still illegal for China to use force, military force, against the peaceful civilians of Taiwan who are going about their daily business and haven't in any way provoked or threatened China.
Right. So I think, and I think this is, I guess you're right that I didn't talk about this particular argument, which I think is prominent and is probably the better explanation for what happened in Kosovo, right? The argument made by the NATO countries was that intervention was necessary to prevent a humanitarian catastrophe in Kosovo, that Serbia was likely to engage in mass sort of atrocities. It wasn't just that they would attack peaceful civilians, but that they would engage in, without the intervention, there would be mass atrocities or a serious violations of humanitarian. So, right. So that is one theory that I think, and that was invoked also in Libya in 2012. I think that is approach. That does turn a lot on the nature of the Chinese attack. So I think your point is well taken that if the Chinese attack is presumed to cause not just sort of a military attack, but one which would not even just a grave military attack, but one that would lead to humanitarian atrocities.
Does it have to be atrocities?
Well,
it's just harms.
Harms. The standard's a little murky. First of all, the idea is quite controversial. So there was a period where the idea of responsibility to protect was promoted in the early 2000s, and a high-level UN meeting was held. But no consensus was really reached other than the fact that the United Nations Security Council should authorize the use of force to protect and prevent these humanitarian catastrophes. But I wouldn't say that there's been a broad international consensus that as to what the standard would be, or when you, or that it's even permissible. I think it's also a minority position, arguably, that humanitarian crisis. But if it is, the threshold would be pretty high usually. Like, so not just a military attack, but one of grave humanitarian consequences that would justify the need to intervene militarily.
So potentially there would be war crimes, there would be
crimes that was a typical scenario that was, again, whether it's legally required to do so, I think we have an expert here maybe.
So I guess I want to follow up because I got to see the PowerPoint before, and humanitarian intervention as such is not really discussed. And the UK has itself endorsed it.
Right.
Itself. And when I look back, and this is how I typically start the US use of force, part of my international law class. In my lifetime, we've had Cuba, Grenada, Panama, Nicaragua, Afghanistan several times, Iraq, 1991, 2003, Iran, oil platforms, drone killings, Islamic State of Iraq and Syria, Libya, and Syria twice. Most of those had some elements of humanitarian element to them. Now, unless you were to say that the US was violating the charter, which some would say, for all or most which I think might be a little inconsistent with your own views on the unitary executive and the presidential power. But I find it surprising that humanitarian intervention is not more in your slides. And it's not just a question of war crimes. When you're talking about an attack on Taiwan, it is almost inevitable that some of that attack will have to be on civilians, especially given the huge lopsided nature of this. So almost every war game that has anticipated what this would look like anticipates something that looks like some of these, like Libya and the things that Gaddafi was up to within his own state of Libya. So that part of it is a little ambiguous, and so I find that part a little missing. Remember also that what this is also turning about is human rights violations, and therefore the self-determination is Article 1 of a broader 2 covenants. And so when people talk about self-determination, they frequently slide into the other parts of the show. That is, what other rights are you violating, and can you use force to resist it? And so I guess what I get from yours, even without the humanitarian part, is that if a lawyer were asked by Trump, US government, to give advice on whether this is legal under international law, I think you would say that it is a good faith exercise of the lawyer's skill to say, yes, you can do it, and it is consistent with international law for the following 5 reasons. And that would be no less a good faith suggestion to the executive than, say, a particular lawyer in the Bush administration suggesting that enhanced interrogation techniques are perfectly legal, which you have defended in terms of not being inconsistent with your good faith obligations as a lawyer under the Code of Conduct, or that it actually is perfectly permissible as a First Amendment right of lawyers to say such a thing. So I guess what you're saying is, if you were serving in the executive branch, or as the top lawyer in the State Department, you would not have to go to that last slide. And in terms of your internal advice, you would say, you're not necessarily violating international law. It's not just Kosovo that's here. It's many of your own examples, in part because there are probably US nationals that are going to be threatened by this. So the rescue of your own nationals in Grenada is there embedded. And there are probably going to be nationals of other countries as well. Where I think you are probably right is that if this happens, and that advice is either given, or in the case of this administration, you don't have to participate lawyer in the advice at all to violate Article 2.4, it seems. So this seems a bit academic in this administration, but let's just go with it. I guess that what I think you're suggesting is that the US might be alone in terms of the actual military action, because many other states, given the power of China, would be reluctant to use the collective part of the show. So this may be more of a ragtag coalition of the willing, as in Iraq 2003, as opposed to the first Gulf conflict. So I guess I put it out to you is, if you were a government lawyer, what advice would you give, and whether you really have to say, yeah, go ahead and violate international law, or could you put it more softly?
Okay, so here's what I would say. So I think you're right that as a government lawyer, I would have no problem. I would feel advising the government, that the U.S. government, that it would be legal to use force to defend Taiwan. And I think, and I have a separate whole set of arguments about U.S. constitutional law, which you've alluded to, but which are more complicated. But related to this one, I would say yes. I think all of these arguments, I think, are perfectly reasonable, and in fact, pretty persuasive. But here's the problem, and this is why the last slide is there, because I think it doesn't win a majority of the countries. And also, there's a further problem with there's some inconsistencies here, because so what the last slide is really about international global public opinion, not about advising the US government, which, as you point out, US government currently is, but even before that, was never super worried about Article 2.4. even less so today. But I think if it was worried about it, it would have very good, reasonable, and even persuasive arguments, but not ones which I think would necessarily prevail with international public opinion, which I think is very important, especially in this contest. It's not just about use of military force; it's about legitimacy. It's about persuading countries that you're in the right, and Ukraine does have that. I think, generally speaking, over Russia, that is something that it is an asset for it in that broader political struggle over Russia. So that's what I'm worried about. That's what I mean. That now, the limited concern I would have is convincing other countries that that we're not in Iraq 2003, because I don't want to be in Iraq 2003, just from a legal point of view, because we had to, the UK spent a lot of time fighting over it, came out with legal opinion that no one's really happy with. Other countries were very reluctant and are going to be more reluctant next time. The US government says, trust us. I know it's a little legally sketchy, but we think this is going to work. So I would like to give some force and strength to this legal argument. And I think it requires a little bit of support beforehand. So in other words, rather than sort of after the fact, dress up the action with some sort of legality, but walk out to the allies now and say, this is why this is illegitimate now. Like, and so China should not even be talking about this. In fact, it's illegitimate for them to be even threatening this. And that's, I think, where this type of stuff is important, even if we never hopefully get to the military conflict. So that's sort of my general take on this. I do think that, though, that's why it's on two levels. Now, humanitarian, let me say something about humanitarian intervention. I guess my reading, to the extent the US government has justified most of their actions, not all of them, they've often invoked self-defense, which is, the US has a very capacious definition of what constitutes self-defense under Article 51. And that has explained a lot of, it's so broad, including defense of US nationals and property and US interests, that it could cover many things, not all of them.
Defense of US nationals.
Yes, in defense of US nationals and property.
That's Grenada, that's Panama, that's a number, and there will be US nationals on Taiwan.
Right. So that is something that is, but those are all self-defense arguments. I think that, it's interesting that the solution to that is for China to say, well, you get out, you have 2 days, leave the country. But putting that aside, I think self-defense is probably the preferred explanation for why the US feels like it has the right to use force. It doesn't work everywhere. Libya didn't have a credible self-defense argument. Kosovo did not have a credible self-defense argument. It had to go in other directions. In Syria, it really didn't have a credible self-defense argument. So they had a lot of problems, but even the drone strikes, many of them are justified under international law of self-defense arguments. So US has been, I think, in my view, more reluctant to endorse humanitarian intervention than the UK. I think the UK has, as a government, embraced that. But I think that's a little bit, but I would say, and I think that my broader point is that I think you're right. This is an important argument I didn't address. And I would say, though, that it does run into the same problems, I think, which is that it has a little bit of we had this fight in early 2000s, and there are a lot of countries that were unwilling to endorse a broader perspective. Having said that, I suppose the moral force of that argument is always quite strong. In other words, once you start painting the scenario of Taiwan, what would happen to Taiwan in such conflict, that sort of marries the legal argument, which I don't think is actually well accepted, but marries it with a very strong, powerful moral argument, which does make it more persuasive, I think. So that's fair, and I take that as a friendly amendment to my slides here. Should I go to the questions, or do you want to continue?
Well, I wanted to follow up, and then the question about how other countries view it is not just popularity contest question. And one of the things you've written previously on this question of self-defense and collective self-defense, you raised the point, I think you just briefly alluded to it here, of what Japan thinks.
Mm-hmm.
And then there's also what the other allies, what South Korea thinks, Philippines, Australia, you mentioned at the end. And they matter more than just the number of votes in the General Assembly, because they would presumably, at least Japan, sure, would be essential participants in some way if the United States was going to try to intervene to defend Taiwan because of the distance involved from Taiwan, the other side of the wall from the US. It's always been very unclear what Japan would do in this scenario. And I'm understating even, I think, the lack of clarity on this. And it's also unclear what South Korea would do and whether they would agree to allow US forces that are based there. So could you talk a little bit about those considerations, as say you have detailed this in some other writings, that Japan's view of the constraints on the collective self-defense right are even more narrow than many other states take?
Yeah, so Japan is complicated because it's intertwined with their constitution, which famously has us, in theory, there's no military in Japan, or there's no army, I guess, and which limits them to self-defense. So whenever the Japanese military could legally be authorized to do anything, they truly need a self-defense. I don't think humanitarian intervention gets Japan anywhere, and under their constitutional theory, because the military is limited to self-defense. Now, that was reinterpreted, and this is the big shift in the early 2010s to include collective self-defense. Now, what that means, though, is not super clear either, but at least that means that has been interpreted to allow Japan to support the self-defense of its allies in defending Japan. So, which they always could, but it did sort of suggest that there's a broader right of Japan to defend its interests. In other words, which is always the theory of collective self-defense, if you're defending another state because it's defending you, or it will result in your defense, that will be justified. But generally speaking, the right of self-defense, as I mentioned, and I think it's fair to say, I don't know that people would disagree. Japan is one of the countries that has what we call a relatively narrow definition of self-defense. In other words, U.S. believes self-defense could be preemptive in many circumstances that other countries don't. And self-defense is, there's certain ideas about imminence, and that Japan also has at least historically endorsed. So whether Japan has shifted a lot, I think, in the last 20 years, I would say. And there was actually a movement to actually just amend the Constitution, and we may even have a prime minister who's, at least in theory, called for it. But actually, if Japan, it's really hard to amend the Constitution. So but they've interpreted it so. That's why collective self-defense is important. And I do think that for Japan in particular, the U.S. needs to come up and can come up with a plausible legal justification. And the de facto argument is the one I would go with. Here is a situation where we have a dispute over what should happen to this place. But the one thing we all know is that the use of force should not be used to resolve it. And that the further point for Japan would be that it's so close to Japan that preventing a conflict here is an exercise in Japan's collective and individual self-defense. Another theory Japan might argue is that they have an island which is only 100 kilometers, less than 100 kilometers from Taiwan. And so any conflict there is directly impinging on, threatening their defense.
Occupied island.
Right, it's inhabited, not even China doesn't claim this is part of China. So that island is sovereign Japan, is 100 miles. On clear days, you can see Taiwan. But anyway, so that would be a further theory. So I think I think the Japanese are historically very formalistic from the American perspective and how they interpret international law. So I think coming up with a sort of relatively formalistic approach would be helpful for rallying allies like Japan, which are constrained also by their constitution to adhere very closely to the international law and the UN Charter.
So your main suggestion, to the extent you're making a suggestion or recommendation in this presentation, is that this should be discussed now, and the US and Japan should at least privately work this out, even if they don't publicly put all their cards on the table.
Right, and also I think we also need a broader public conversation as well. I think that the governments are not able to do the Taiwan government is not able to do this. I think in the way that a normal government might, because they're constrained by their complicated status in political sort of commitments and their constitutional limitations. But what normally this would all come from Taiwan. They're the ones who are most interested. But I do think that countries outside of Taiwan who think they might be involved in a conflict should be thinking, just like we are currently thinking about the military aspects, right? We're wargaming, right? But we need to think about the policy war game. There's the economic war game. I think it's not wrong to start thinking about the legal war game and start airing out these arguments in public in forums like this one, which I appreciate the opportunity to do so that great scholars like Jose and you can sort of work and talk about what would be the arguments that would explain and would also delegitimize, in my view, delegitimize the idea, which what I'm worried about, I guess, let me put it another way. I'm worried about the idea that China using force in Taiwan is becoming kind of normalized. Like, this is okay because it's part of China, right? What's the big deal, right? I think that needs to be sort of delegitimized if we can, and the law, a credible legal argument that it's a violation of the UN Charter is one way to push back on that.
So I actually exactly have a question about Japan, but before I do that, because we're from outside NYU, I feel like we have to present ourselves. We're a group of us from Fletcher School of Law Diplomacy with cross-enrollment in town, Mosaic Research from Spain, China, Taiwan, Hong Kong, and like we discussed this story exactly that I discussed with a Japanese naval officer, also civilian official in the Ministry of Defense, Japan Ministry of Defense, because Yonaguni Island is just right outside Taiwan, and then last year, North Korean missile test actually fell right outside. So my question, modifications like with the U.S.-Japan mutual Treaty of Mutual Cooperation and Security, how would that change your calculus? Because that's right outside Japanese EEZ. So how do that invoke like Japanese self-defense in relation to also American? That's one. Second would be on state practice, because PRC actually supported the independence of East Timor against Indonesia in the 70s, and they argue vehemently at the UN for East Timor independence with the use of force. So how would that modify your analysis on how to weaken Chinese position in that regard? Thank you.
Okay, thanks, and thank you so much for coming from far distances, all the way to Boston, right? It's like foreign country over there. All right, so just quickly on the Japan thing. So the Japan treaty is always fascinating me because it's a one-way treaty. So the U.S. has to defend Japan, but Japan doesn't have to do anything with the U.S. So hopefully no one's told President Trump about that part of that treaty. But it does mean that Japan, though, the U.S. is committed to support Japan in defense of the territories it administers. So that actually includes Senkakus, so even disputed territory. So there's some weirdness there. But I think that treaty, so in a situation where Japan, and I think this would be easier for Japan, credibly feels like that their territory is being threatened, right? Then I think that would be a straightforward application of the treaty. The problem is, I think, and I guess just as a practical matter, the Chinese, I think, are very smart and they know this. And so I think they would be pretty, if they were, well, it would be very savvy for the Chinese government if they want to embark on this to try to split off the different countries. And so keeping, not giving Japan any excuse to sort of invoke self-defense, I think would be the smart thing to do. And they can do that. They don't need to threaten Japan in order to carry out their operations against. The geography is not quite so tight, I think. So that's why I think it is a potential argument, but one I think the Chinese could relatively easily avoid. On East Timor, I would say this: China has gone through different stages, but the one thing they're always pro former colonies or And the big divide in self-determination is over the idea that the right of external self-determination extends beyond the former colonies situation. So for East Timor, it's a former colony. Now it's complicated because it's Indonesia. It's not. So there is some ambiguity there. I grant you. But China has been relatively aware of the concern about self-determination in Taiwan. So they have always taken the position that it should be limited to a narrow set of circumstances in the post-colonial situation. And they're not alone in this view. And so I think that I think it's a good example, and I think it's a good one. I probably should mention more, but it is, I think, the way that would be explained is that this is a colonial separation argument. But you're right, since it's Indonesia, it is kind of a different, as opposed to the Netherlands, is a different cast to that argument. And I think that what I think was just the larger thing is that the Chinese, I've been watching the Chinese government foreign policy pretty close to the last decade or so, and you know, it's true, they really are driven by Taiwan. Like self-determination, they're all over that. They're very careful to be consistent with their position on Taiwan. Kosovo, they're all over that. They want to be very clear. This has nothing to do with Taiwan. Ukraine, they're all over that. This has nothing to do with Taiwan. So, and the U.S. government is just not focused on this, and other governments aren't, and so they just don't care. So, one of the things I've observed in general is that, and it makes sense. Taiwan's one of 5,000 things the U.S. government cares about. Taiwan's like number one or number two for foreign policy of the Chinese government. So they tend to be very good at focusing on all the details of every little area, everything that might implicate their Taiwan position. Their diplomats are incentivized to go after it, whereas our diplomats just got a lot going on, right? So, and so I think that creates an asymmetry that's hard for the U.S. to catch up on.
I want to add to like self-determination because like I'm close, like close, I cannot say that. Like with Deep Green Taiwan Huimin show, they're talking about KMT colonization time. So
Yes.
that like then it builds to what.
Yeah, so that is the argument. I think the interesting part of that argument is, and that argument was really developed in the 70s, when in the 60s and 70s.
Spell that argument out a little bit for some in the audience.
Right. So I think in this idea is that Taiwanese are, one of the things you have to establish is that you're a people under international law in order to have the right of self-determination, and that typically is a variety of factors that I won't go into here, but that often the scenario that has often been described as sort of a colonial, and but you're being oppressed by an outside force that's not you. So some other people is oppressing you, and so that fit pretty well, I think. Well, my family's on the other side, but still, that could arguably fit with the mainlanders moving to Taiwan in the 40s, and then sort of kind of dominating the government, and then sort of preventing the Taiwanese people who have a separate dialect and culture and history from exercising and controlling their future. And there's a prior history for Taiwan, even before the Japanese took over. But you know, so that's a complicated story about Taiwanese people being a people. What I think that's the argument is a little murkier now, where, and I think this is why that Taiwanese people, so many generations out, have lost a little cohesion of, because it's, you know, the people of Taiwan are now in a weird way more kind of like each other. There's less separation. You know, I of course there are still people who are very much separate, but there's less separation. So there's much more of an amalgamated society. So that society is more accurately described as, and also those people are arguably in control of their government, right? So how are they being suppressed by the outside force? Here, the outside force would have to be China, but China's not directly preventing them, unless they use force, from controlling their political development and their future. So I agree with you that the Taiwanese people had the claim to self-determination as a colonized by China, by the Kuomintang of China. But I think that argument is kind of different in today's context, where they have internal, we call it internal self-determination. They're running their own state, and China could say, "Hey, you're running your own place. Right? What self-determination you need?" You know, so that's why I think the argument actually is kind of harder to make now, ironically, because of Taiwan's democratization and it's sort of the success of Taiwanese in sort of melding together a society that both mainlanders and Taiwanese. I'm a mixed marriage. My mom's Taiwanese, my dad's a mainlander, so I'm always a big believer in blending. But that story is more complicated today than it was, say, 50 years ago.
So we have a number of questions from the online audience about this issue of peoples and being a people. So this is a good time to bring that in. One of them is asking about the relationship of that argument to the relationship of the definition of peoples under the ICCPR or the ICESPR Article 1s and the definition of group in the Genocide Convention, which talks about a collective right to existence. So are we talking about the same potential victims, I guess, between peoples and group in those two different contexts. And I think they're saying, does this apply in the Taiwan case? So can this do any work for an argument?
Well, the Genocide Convention has gotten a lot more attention recently because of the Israel opinions and the ICJ opinions on it. And I have to admit I haven't thought enough about this. My general understanding of Genocide Convention though is that it's intended to have a broader protection. So you don't have to be a peoples to not be genocided. In other words, right? So, but in other words, like the Genocide Convention should be a broader protection beyond just you don't have to establish your post-colonial and so that actually in a weird way that could work better for Taiwan if there's a credible claim that they were of suffering genocide, which is itself but I have myself personally have a relatively high threshold for what I believe the Genocide Convention actually means when they say genocide. But having said that, I think it is in terms of what groups could claim, my instinct is to say it's probably intended to say broader because genocide is bad, so we don't want it to happen. And so you don't have to go through the different hoops of being a peoples to get protection on the Genocide Convention, my theory. And I know it has been invoked, it's been invoked by other countries outside the Israel context, which I think Ukraine has argued, right? That and so there's a lot of different arguments about how genocide could work. The difference is that, of course, as a formal matter, the Genocide Convention, the mechanisms of the Genocide Convention, like the tribunals, the international court, it's not going to work for Taiwan. But the principles of it, I think, could be deployed, I think, as a way to sort of flesh out the humanitarian argument, perhaps, that we've been talking about earlier. There is some evidence that because language from the Chinese government sometimes suggests that and certainly that they're going to punish, arrest, and, put in prison all those Taiwanese secessionists with death penalty, that I think does get closer to, and that they're going to stamp out, Taiwanese identity, or that they don't really say that, but they complain about the use of Taiwanese history in Taiwanese schools and the idea that they're not being Chinese enough. So there's some flavor of that. I myself don't think we've kind of gotten there yet, where there's statements that suggest they're trying, genocidal, but I think there's some flavor of it in some of the statements that have been coming out of China.
Okay. So another question is, how is peoples defined in both theory and in practice? Does it have to turn on shared ethnicity and language being different from that of the attacker, or could it turn on having a political community that self-identifies? So what I understand that to mean is, the Taiwanese people coming together, for example, every 4 years and voting as a political community that is distinct from the people of the mainland, even though ethnically and linguistically they seem very similar.
Yeah, well, this is a very deep question that and I'm not sure I'll have the complete answer to it. The general, I think, the most powerful sort of examples which have been endorsed and accepted in international law are where there are literally different racial, ethnic, language groups. And that's, again, the post-colonial context. So the most powerful examples would have been, European, the classic scenario people think about where the origin of the self-determination is a foreign, often European, dominating another country, which another peoples that has of different race, religion, and they have everything, right? Language. But of course, there are lots of people who evoke the right of self-determination, Quebecois, and although there's a language, there's not the maybe not the ethnicity to Scottish, Catalonians, right? There's lots. So the idea has been expanded and is contested. I know it's disappointing to say that, but I wish I could say more. But there are many people who have evoked the right of self-determination, and so one of the battles in the scholarship among countries has been one group's like, well, no, it should be a very narrow, especially external self-determination is very narrow, because secession is something that we are against, right? To the extent the more you have a broader conception of self-determination, the more likely you're going to get secession. But secession is also disfavored by many under international law, arguably, because the UN Charter says everyone gets their territorial integrity, right? So those two forces are in tension. So there are lots of groups that do evoke it. I think language is typically helpful. But we also see many examples of countries that share ethnicities and language, which are perfectly happy separate. A purely political separation does seem less to fit under the classic scenario. That's why there's always a flavor. Even the Scottish, who to an outsider, an American, when I went to Scotland, I'm like, well, they're speaking English, but they immediately went, no, it's totally different.
You have a different accent.
Yes, but it's very different, obviously. I know Catalonian's not Castilian. But the languages do seem to be the thing the European sort of examples seem to hone in on. That none of that really fits perfectly in the Taiwanese scenario, I think. And so they don't really have the language. I mean, I know Taiwanese, which I can speak a little, it's very different. But
There's one little
yes,
wrinkle on
yes.
that is if to the extent we're looking for legal examples where courts have accepted this, I think a leading example of a quite flexible determination of what is a separate group that is subject to oppression would be the cases on Rwanda with Tutsis and Hutus, where the relevant court, the tribunal, the ICTY, has said self-identified people, and in this case was just aided by ID cards issued by the colonial master, but then carried forward so that people knew themselves to be Tutsi and knew themselves to be Hutu, even though many, many grounds, including language and everything else, it was impossible for an outsider, was enough. And so the question is, along the lines of what Catherine's question from the chat box, is if the people are defining themselves to be separate through a political determination, put democracy aside, because I don't think that international law particularly values it, and that is what's being oppressed, then you have an additional argument that I think would help the Taiwanese. That is, what is being oppressed here is, for example, the ability of Taiwan to self-govern itself so that it's unable to conclude any human rights treaty and has to go through all these hoops in order to abide by them through national law. And so that's a political infringement that isn't directly connected to declaring independence or its inability to be an observer in the World Health Organization and participate on vaccines or health to its own people. There are a variety of things where China has closed the door to what many people would call sovereign status, just not an official status, but the ability to take advantage of this interconnected world, including international organizations, that is increasingly denied to them.
Right, so I think that's a very powerful argument. I do wonder how many examples of state practice we have of a group really being accepted, because I think the key factor here, I expect, is that they've been oppressed because of their group identity, right? So, sometimes it's easier, the Hutus, where they had their self-identification for a variety of reasons, but when you're being targeted because of your identity in this political community, then that typically does strengthen the argument that therefore we're a group that should have the right to determine their fate. But they're not always the same concept. So the group that's protected from genocide or other human rights atrocities doesn't always have the right to self-determination, but often in Kosovo they sort of kind of blended these ideas together because they're suffering, they kind of link to the idea of self-determination. What I would say though is that there is, and I think that argument that Taiwan's inability to participate in international fora is there. I'm not sure that's typically what the classic cases of self-determination we're thinking about, but I think maybe adapted to the modern era it's not implausible to me. I just think that it's self-determination it's a popular concept, but it's very difficult to find examples where there's wide consensus on, everyone agrees that's self-determination and they got the right and that's why. There are some examples that are easier, and the easiest ones are the post-colonial examples, which Taiwan would have a harder time fitting. And we see some evidence like the Quebec example. The Supreme Court of Canada was kind of conceded they sort of do, but not, they kind of try to divide different kinds of self-determination. So there's some state practices suggesting self-determination has a broader conception. Yeah, I'm sorry.
Maybe if we look at Palestine and how its observer status and then it's being recognized by a lot of countries now, and maybe like putting the example of Palestine as being able to engage in these international organizations, and because it's now being recognized by so many states, could help that argument. And also, I just have a question. So, in terms of what you said about the US and trying to build legal arguments with its allies, focusing in the EU and the UK, what do you think? Probably is different, but what do you think would convince them about helping Taiwan? Maybe not getting involved directly military, but about supporting the US and.
Yeah, no, I mean, that's a great example. We saw the divide over Iraq within US and Europe. It wasn't obviously, there are many factors, but international law was obviously one of the reasons and affected that division in their approach to Iraq. And I think that lesson, I think is important to figure out how to manage this. I think that revealed that there are some differences in their views on how to interpret the right of self-defense. And so I think that for the Taiwan scenario, I think what the US, with respect to the UK, should probably draw on the humanitarian argument, I guess, in which argument that is, I think, still well accepted in the UK. But I don't find that that was necessarily something, and that was also, in theory, I guess when we take a step back, I think what we're going to want is something that NATO has already endorsed, which it did in Kosovo. So the Kosovo example is probably most of the obviously NATO countries signed on to that. So they're kind of, that example could help shape how they might respond to a Taiwan crisis from a legal and practical point of view. They wouldn't necessarily intervene, but whatever their justification is for intervening to protect Kosovo could, I think, be built upon to persuade them to support Taiwan in that scenario. And I think for the European countries, I think, potential human rights violations, I have a stereotype.
Yeah.
They like human rights in Europe, unlike Americans, I guess. And the preventing catastrophes, preventing disasters, those are the types of arguments I think that probably do have a little bit more push in Europe. And it's important to get everyone on board, because the countries that are the most that have not signed on to the Taiwan as part of China, many of those are in Europe, because they were cautious, just like the United States was, in not taking on that position at the time when they reestablished relations with China. So that's an area where I think US could build support, but it's tricky. And so you have to prioritize countries that you need more and then countries you need a little less. Again, as Professor, we're talking about like a very almost, it does seem a little weird to talk about all this in our current situation, but I think in the long run, all these things still seem to have an impact on foreign relations.
So I've got my eye on the clock, and there's so much more to ask.
Oh, okay.
But I just want to kind of maybe pull a couple of questions together in a big ending question. But first, make one quick observation that somehow we haven't mentioned one way that I could envision this happening today, which is if there is an attack on Taiwan, the lack of recognition of Taiwan and its unclear status can very quickly be cured by President Lee in Taiwan immediately declaring Taiwan as a state, and President Trump immediately putting on social media that he hereby recognizes the state of Taiwan and welcomes it to the international community and proceeds. So
Right. This is sort of
Only if they have a plane to give him.
but I acknowledge what
I think they do. They do have a plane.
We've broadened the conversation though beyond just whether we've papered over an American response. We're now asking probably the more important question about the world's reaction and so on. So based on that fact, the conversation we've been having, want to combine. So basically, and this is Jerry's old question, what is to be done, right? You've said there should be a conversation about it. Sometimes we're now hearing the call for the US to drop strategic ambiguity. So should the US drop the ambiguity of its position? Should Japan and other allies also drop the ambiguity position and say what they would do, or at least somewhat more clearly signal what they would do. And the question from online of are there any tools that the UN and the international community have to mediate or to take some kind of preventative measures to stop armed conflict? Because conspicuously, nobody is trying to do anything except arm Taiwan more.
Yeah, I mean, okay, so this is, first, let's talk about the green button scenario. I always call this the green button. So it's like the Chinese are coming, press the green button, and all of a sudden we're independent, change the flags. There's something attractive about that scenario, and then I think you can imagine some president saying, and we recognize that. I think that would, I guess, solve our problem domestically. But I don't think we have a huge problem domestically, internationally. I think the problem is the problem I mentioned, that a lot of countries are very committed to the position that Taiwan is part of China. So we're going to have to reverse that if we, and that's going to be hard to do, obviously. So, there's some kind of interesting, to the extent that Taiwan's going to want to argue, it needs to lay the groundwork. In a weird way, you see this contrast with Palestine, which has wide recognition, but actually very little actual control. And Taiwan, which has complete control, but almost no actual recognition. The contrast is quite interesting. It makes you think maybe it doesn't really matter, but it sort of does matter. But I think Palestine has been very powerful in international sort of organizations and broader public discourse and NGOs, and sort of building support for its statehood argument. And Taiwan has been unable to do that because it has an antagonist that has really kind of locked up, as I said, 3/4 of the world. So I just think that scenario doesn't really get us as far as I think people who are worried about Taiwan would want. And also, and it goes to the other problem of the reason why countries are a little ambiguous is because there's always a fear of provoking, right? Why provoke China? I do think, though, that and this is purely policy-wise, I think it's not a bad idea to drop the ambiguity in this sense and say that, and the US sort of just could be a little more explicit and get other countries to say this, is that Taiwan's future is not a matter for China to resolve alone by the use of force, right? That this is a threat to international peace and security, right? This is something of international concern. It's not just Taiwan, China. This would affect and does affect the whole world, and the whole world should care. Europeans should care, Africa, everyone should care. And therefore, we oppose the use of force, and everyone else should oppose the use of force to resolve this problem, right? Just like we oppose the use of force in other places, right? I think making that clear, and then we would use, you don't have to say we would use force to do so, but we strongly oppose, and we would act to protect and prevent sort of a catastrophe would be a coherent position that a lot of countries could sign on to. Right now, the economic argument obviously is the easier one to sell, and also all your computers and AI things will collapse, and that gets a lot of people's attention, right? The one way to build support in America would be to threaten to take away everyone's phones, and no, but like you couldn't use your phone. Right, America would just collapse. The Americans under 20 would collapse 15 minutes if their phones turned off. So, so there's an economic threat. But I think there's also the broader claim. This is an important question. It's like Jerusalem. It's like there are other places in the world that we just need to have the world sort of come together and work to try to resolve peacefully. And of course, we haven't even done that with Jerusalem. But that there are things that we should care about in the world. Taiwan's one of them that everyone should care about, and that using force to resolve that is something we should not be willing to accept. And dropping any ambiguity about that, I think, would be helpful. Technically, that is U.S. position. We're against it, but I think we should make it more explicit.
Would that be a UN General Assembly resolution?
Well, when you lose, you don't want to lose those resolutions. But yes, it's something. In the ideal world, that would be the situation,
that would be the way to do it, ideally, yeah. What about the question of some kind of an intervention to mediate or to promote a peaceful solution? I fully realize that Beijing has more or less said they wouldn't participate in anything like that because it's entirely an internal affair, but countries say things and then they do other things. So.
Well, I mean, I think I saw a comment just yesterday. President Lai made a statement that President Trump should get the Nobel Peace Prize if he could convince China to stop threatening the use of force against Taiwan, right? Actually, like a pretty slick statement in the sense, and also he's been hanging out with MAGA podcasters, also smart for him, I think, at this point. Because, but actually, not that we need to just spend our time trying to manage President Trump's ego, but really any president actually, would be setting it up as a scenario where this is a thing that you could help us resolve and mediate, right? And it's not even just President Trump, although I'm sure he would love to do this, right? And making it international rather than a purely domestic question is actually better for Taiwan, I think. Ironically, even though they're not a state, because the more this becomes a question of international concern and potentially a threat of national peace and security, and not just a domestic bilateral conversation between two political parties, the better it is, I think, for Taiwan in making it harder, more costly, more dangerous for China to intervene militarily. And so that's why I think that's a smart idea. To say, look, when you talk to your buddy President Xi, why don't you tell him, hey, I can work out this thing where you don't have to invade Taiwan. Now, maybe he's not the best person for this, but some person to try to make this more of an international conversation, I think is better. It's better because Taiwan, again, its great weakness is its lack of international standing to be able to have a megaphone. It needs other countries to state and to make this an international question and not a domestic one.
I think we're out of time, so I want to thank you very much for adding your analysis to the rich body that we are building up, actually. And so please do come to our website, and we will be putting this recording on the website. We will also have written excerpts of it, and then we have forthcoming some other research products that we'll be putting out.
Thank you.